Welcome to the deep dive. Today, we are really digging into something that sounds simple, but often causes a lot of headaches. Statute of frauds.
Yeah.
Yeah, specifically that one-year rule.
Yeah.
Our mission today is to figure out when an oral contract, one that maybe looks like it could go on for years, is actually okay because it has like a built-in escape hatch and express termination clause.
Mhm.
How do courts figure out if it can be performed within a year when someone can just, decide to end it early?
That really is the million-dollar question, isn't it? And it all comes down to a pretty subtle legal difference. Are we talking about an excuse for not finishing the contract, or is ending it early actually completing the performance in a way the contract allowed? This has caused a major split in how different courts handle it. So today, we're going to look closely at that split and then really model the analytical steps, step by step, using a key case. The goal is to give you a solid framework so you don't get tripped up by this.
Okay, sounds good. Let's start with the basics then. Before we even get to the termination clauses, what's the fundamental test courts use for the statute of frauds one-year rule? Just the general idea.
Okay, so the general rule, and you see this in cases like McKinney v. Black, it's all about possibility. Not probability, not likelihood, just pure possibility. The question is, based on the contract's own terms, is it possible to fully perform it within 1 year? If the answer is yes, then it's outside the statute of frauds. It doesn't matter if everyone expected it to take longer or if it probably would take longer. If there's any way it could be done in a year under its terms, it's safe.
Possibility, not probability.
Yeah.
Got it. Okay, but here's where I, and probably many others, get confused. How does that simple rule work when you have a contract that explicitly lets someone terminate it early? You mentioned a split.
Exactly. This is where the paths diverge. There are two main camps. The first is often called the majority rule, and it's associated with thinkers like Williston. This view focuses on something called defeasance. Under this view, if a contract is set up to last more than a year, but it has a clause allowing it to be terminated early, like, say, if a specific event happens, that termination is seen as defeating the contract, not performing it. It's like an external event cutting things short. So these contracts are usually held to be within the statute.
Right, so the termination is like an unplanned stop, an excuse for not finishing the full term originally envisioned.
Precisely. It's an excuse for non-performance. But then you have the other side, the minority rule. This is the approach California follows, and it has roots in cases like New York's Blake v. Voigt. This view says something totally different. It argues that if the termination option is actually written into the original agreement, exercising that option is a form of performance. It's one of the ways the contract was designed to be completed.
Okay, so one view sees termination as breaking the contract. The other sees it as fulfilling one of its potential paths. That's a huge difference in perspective.
It really is.
Let's make this concrete then. Let's analyze Hopper v. Lennen and Mitchell. That's the big California case on this, right? First, can you lay out the legally important facts for us?
Sure. So the appellant was Hedda Hopper, a well-known radio personality back then. She made an oral agreement with Lennen and Mitchell, an advertising agency. Hopper was supposed to provide her services for radio broadcasts. The deal had, well, a flexible duration. It started with a minimum 26-week period, but it could potentially extend up to 5 years, broken into 10 of these 26-week cycles. But here's the kicker. The contract explicitly allowed the employer, Lennen and Mitchell, to cancel the deal. They just had to give a written notice 4 weeks before the end of any 26-week period. Hopper eventually sued Lennen and Mitchell after they repudiated the agreement before the 5 years were up.
Okay, so a 5-year potential deal, but the employer could get out every 6 months. What was the core legal issue the court had to decide?
The precise question was this. Is an oral contract like this one, potentially lasting 5 years, but giving the employer the option to terminate much sooner, every 26 weeks, void under the California statute of frauds? Specifically because, maybe Hopper herself was stuck for the long haul, even if L&M wasn't.
Got it. And what rule of law did the court apply to figure this out? Can you state the rule and break down its testable elements?
Right. The court applied the rule that a contract is outside the statute of frauds if its terms make performance within a year possible without departing from those terms. The whole analysis really turns on whether exercising that cancellation option counts as performance. The court effectively broke this down into 3 key questions or elements.
Was the agreement truly incapable of being performed within 1 year?
Did exercising the termination option count as fulfilling the agreement as the parties originally intended it might be fulfilled?
Was the party with the obligation, Lennen and Mitchell here, actually bound for more than a year?
Okay, thank you. That's clear. Now let's do this court's elemental analysis. We'll go step by step. How did the court handle the first element? Is the agreement incapable of performance within a year?
Okay, so for element 1, mini IRAC time, the subrule is that performance has to happen the way the parties agreed. Here, the court looked at the contract structure. L&M was only bound beyond 26 weeks if they chose to be. They could simply decide not to continue after the first or any 26-week period. If they did that, say, after just 6 months, the contract would be fully performed according to its specific terms. So the court's application was, performance was possible within a year. Therefore, the conclusion on element 1 was, no, the contract was not incapable of performance within a year because L&M could end it quickly per the agreement.
Understood. That makes sense because L&M had that early exit. Now, for what seems like the real core of the debate, the second element. Does the exercise of the termination clause fulfill the agreement as originally contemplated? How did they tackle that?
Right, this is where the court really embraced the minority rule, mini IRAC 2. The subrule here is distinguishing completion from defeat. The court reasoned that this termination clause wasn't some external accident like a fire or something. It was a specific term the parties agreed on from the beginning. So when L&M exercised their option to cancel, they weren't breaking the contract. They were executing it exactly as planned, executing one possible pathway the contract explicitly allowed: application. Termination here was fulfillment. The conclusion on element 2 was, yes, exercising the termination clause was a way of fulfilling or completing the agreement as intended.
That internal versus external distinction seems absolutely critical. Okay, finally, how did the court address the policy behind the statute of frauds with element 3? Is the obligated party bound for a period greater than the statutory limitation? You mentioned this relates to why we have the rule.
Exactly. Mini IRAC 3. The policy concern is preventing claims based on unreliable memories of long-term oral promises. L&M argued, essentially, that the statute applies to contracts not to be performed within a year, not ones that might be defeated within a year. But the court rejected that line of thinking. Because L&M, the party being potentially bound for 5 years, could actually terminate their own obligation every 26 weeks, the court said they were never truly bound for more than that shorter period at any given time. Application. L&M always held the keys to limit their own commitment to less than a year. This meant the core danger the statute of frauds aims to prevent, being stuck in a long-term obligation based only on spoken words, didn't really exist for L&M. The conclusion on element 3 was, no, the obligated party, L&M, was never actually bound for longer than the statutory period.
Okay, so pulling it all together. Performance was possible within a year, element 1. Termination was fulfillment, not defeat, element 2. And the obligated party wasn't actually bound long-term, element 3. After weighing all that, what was the court's final conclusion?
The final conclusion was that the oral contract did not violate the California statute of frauds. Because performance within a year was possible, according to the contract's own specific terms, including that termination clause, the agreement was valid. Hedda Hopper could proceed with her lawsuit. The dismissal was reversed.
That step-by-step breakdown makes the Hopper reasoning much clearer. It really hinges on that termination clause being an internal mechanism for completion. All right, to really hammer home this difference between performance and defeasance for you listening, let's try a couple of quick, maybe slightly unpleasant hypotheticals. Imagine an oral contract for a very specialized, messy job, cleaning a huge industrial waste storage tank. It's potentially hazardous stuff. The contract stipulates a mandatory 3-year cleaning schedule. Okay, hypothetical one, defeasance focus. The contract says the 3-year term is absolutely required. But it also includes a clause stating the contract becomes void immediately if the EPA unexpectedly shuts down the entire facility. Does that EPA clause save the contract from the statute of frauds?
No, definitely not. That EPA shutdown is a classic example of defeasance. It's an external event, governmental action, that frustrates or excuses performance. It doesn't mean the contract itself could be performed in a year. The contract, by its core terms, still required 3 years of work. The EPA shutdown just stops it. So under both the majority rule and even the logic Hopper rejected, this contract would fall squarely within the statute of frauds. It needs to be in writing.
Right, external event, likely SOFEF issue. Okay, hypothetical 2, Hopper performance focus. Same 3-year cleaning schedule. But this time, the contract explicitly allows the facility owner to terminate the agreement without needing any specific reason, right after the first phase of cleaning is successfully completed, which only takes 3 months. Now what?
Now that sounds exactly like Hopper. The owner's option to terminate after 3 months is an internal, agreed-upon way the contract might conclude. It's part of the deal's design. If the owner exercises that option, the contract has been performed according to one of its originally contemplated paths. Because performance could be completed within 3 months under its terms, this contract is outside the statute of frauds. It's likely valid, even if just oral. Okay, so let's synthesize everything we've covered from Hopper and the general rules into that actionable checklist for you. Here's a step-by-step diagnostic you can use when you spot a potential so-called if duration issue involving termination clauses. Step 1. Spot the issue. First, is the contract oral? And second, does its stated term or the nature of the performance clearly suggest it will take longer than 1 year? If the answer to either is no, you can probably stop here. If yes, move to Step 2. Step 2, test for impossibility. Looking only at the required performance without considering any termination clauses yet, is it truly absolutely impossible to complete that performance within 1 year? Think like building a skyscraper that structurally takes 5 years. If it's impossible, the SILF generally applies right away. Step 3. Find the escape hatch. If the main performance could take longer than a year, but isn't strictly impossible within a year, now look for an escape hatch. Does the contract contain an express clause allowing for early termination? Step 4. Distinguish termination. This is the crucial Hopper analysis. Classify that termination right. Is it triggered by something external that frustrates or excuses performance like death, destruction of subject matter, government action? If yes, you're likely in majority rule territory, and the contract is probably within the SOFA. Or does the termination clause represent an internal option, a mode of fulfillment or completion specifically agreed to by the parties, like L&M's option to cancel an Hopper? If yes, you're likely in California minority rule territory and the contract is outside the SO.
That framework is incredibly useful. So the big takeaway really seems to be that the power dynamic matters. If the party potentially stuck in the long-term obligation has a built-in contractual way to end it early as part of the deal's design, that power often saves the oral agreement from the statute of frauds. It was L&M's power to cancel that saved Hopper's deal, ironically. What this means for you is that sometimes, even in these complex legal areas, the entire outcome can pivot on understanding the nuance between just two words. Is termination defeasance, or is it performance?
Exactly. And that leaves us with a final thought for you to consider. What if the Hopper contract had been slightly different? Imagine if Hedda Hopper herself had the option to terminate every 26 weeks. But if she did, Lennen and Mitchell would have had to pay her a hefty penalty, say $1 million, for canceling early. Would that large financial penalty change the analysis? Would Lennen and Mitchell still be considered not bound for a longer period if exercising their termination right came at such a high cost? Something to think about how practical realities might influence that legal analysis.